In any public controversy, disagreement is expected. Commentary, rebuttal, even sharp criticism all fall within the normal boundaries of online discourse. But there is a point where disagreement ends and intimidation begins. According to multiple reports surrounding the Whittaker case, that line may have been crossed. Over the past several days, a pattern has emerged that no longer centers on debate about facts or interpretations. Instead, it centers on allegations of harassment, doxing, and intimidation directed at individuals who have publicly criticized people connected to the Whittaker exploitation case. At the center of this escalation is the claim that a video targeting one of those critics was uploaded and then rapidly removed by the platform for violations related to bullying and harassment. The speed of the takedown is notable. Platforms typically do not remove content unless it clearly violates policy, especially when it involves targeted harassment or threats. What followed next moved the situation out of the realm of online drama and into potential legal territory. Concerns about intimidation were formally raised with the West Virginia State Police. During that communication, investigators reportedly asked whether the harassment appeared to be connected, directly or indirectly, to Patrick Rourke, who at the time was out on bond following his arrest in connection with alleged exploitation tied to the Whittaker family. That question matters because once a person is under court supervision, whether bond, probation, or pretrial conditions, the law draws a firm boundary. They cannot engage in intimidation, nor can they use third parties to do it for them. Threats, doxing, or coordinated harassment carried out by associates can be treated as third-party intimidation, a serious violation that can carry additional legal consequences. According to the information provided to authorities, at least one individual allegedly involved in the harassment has documented public associations with Patrick Rourke. That association alone does not prove wrongdoing, but in legal terms, affiliation plus benefit plus timing can trigger scrutiny, especially when the conduct appears designed to silence criticism related to an ongoing criminal case. This is where the narrative shifts. The issue is no longer whether someone agrees or disagrees with commentary about the Whittaker situation. The issue becomes whether intimidation is being used as a tool to control the narrative, and history shows why that matters. In cases involving alleged exploitation, especially of vulnerable individuals, intimidation often appears at the moment scrutiny intensifies. Not because critics are necessarily wrong, but because pressure exposes instability. When facts are strong, rebuttal is enough. When facts are weak, pressure tactics appear. What makes this situation especially concerning is the broader context. The Whittaker family remains fractured. Legal questions remain unresolved. Financial transparency remains disputed. And instead of public focus shifting toward restitution, safeguards, or family reunification, attention is being redirected toward attacking critics. That redirection benefits only one group, those under scrutiny. It does not benefit the Whittakers. It does not clarify the truth, and it does not reduce harm. From a systems perspective, intimidation serves one purpose: to chill further inquiry. If people believe that speaking out will lead to harassment or exposure, fewer people will ask questions. Fewer people will dig. Fewer people will demand accountability. Law enforcement agencies are trained to recognize that pattern. That is why allegations of harassment tied to an ongoing investigation are not treated as side noise. They are treated as potential extensions of the original conduct. Another important distinction must be made here. Raising concerns to authorities is not retaliation. It is procedure. When harassment escalates to threats or doxing, reporting it is not escalation. It is containment. The individuals raising these concerns have stated that they are not anonymous figures hiding behind fake profiles. They are identifiable, reachable, and willing to answer legitimate questions. That openness stands in contrast to the use of shadow accounts, proxy harassment, or removed content. This contrast matters. Transparency reduces suspicion. Intimidation increases it. The broader question, then, is not who dislikes whom online. The real question is why. At this stage of the Whittaker case, pressure is being applied outward instead of accountability being applied inward. If the goal were truly to protect the family, energy would be focused on ensuring legal representation for the Whittakers, clarifying consent and authority, documenting financial flows, supporting reunification where appropriate. Instead, according to these reports, energy is being spent on silencing critics. That choice has consequences, because when intimidation enters a case already under investigation, it doesn't protect anyone involved. It expands the scope of scrutiny, and it reframes the story. The focus will shift to how third-party intimidation is evaluated legally, why affiliation matters more than intent, and how attempts to suppress criticism often end up strengthening the very cases they are meant to weaken. When harassment replaces rebuttal, what does that usually signal? Confidence, fear, or loss of control? Once intimidation enters a public controversy tied to an active investigation, the framework changes completely. What might look to outsiders like online chaos is treated very differently by investigators, courts, and supervising authorities. The reason is simple. Intimidation is not speech. It is conduct, and conduct has consequences. To understand why the allegations of harassment and doxing connected to the Whittaker case are being taken seriously, it helps to step away from personalities and look at how third-party intimidation is evaluated in real legal terms. What third-party intimidation actually means. Third-party intimidation does not require a direct threat from the person under supervision. In fact, most cases don't involve direct contact at all. Instead, investigators look at patterns. The standard questions are: who is being targeted? Who benefits from the intimidation? Who is connected to the people doing the intimidating? Did the intimidation occur after criticism or exposure? Is there an ongoing legal matter that could be influenced? If those elements line up, intent does not need to be proven in the way people assume. The law does not require a recorded phone call saying, "Go threaten them." It requires reasonable inference supported by context. That is a crucial distinction. Why affiliation matters more than instructions. A common misconception is that someone must explicitly order harassment for responsibility to attach. That is not how supervision rules work. When a person is out on bond or probation, the expectation is proactive restraint. They are responsible not only for their own conduct, but for preventing their circle from acting on their behalf in ways that interfere with justice. That is why affiliation matters. If individuals who are publicly aligned with Patrick Rourke are engaging in harassment that benefits him, by discrediting critics, suppressing discussion, or intimidating witnesses, authorities do not treat that as coincidence. They treat it as risk, and risk is exactly what bond conditions are designed to manage. The benefit test. Who gains from silence? One of the strongest indicators investigators look for is benefit. Intimidation does not need to succeed to matter. It only needs to be aimed. If critics stop speaking, questioning, or organizing, the person under scrutiny gains breathing room. That benefit alone is enough to justify further examination. In this situation, the intimidation allegations emerged after public criticism of financial conduct, questions about unpaid obligations, renewed focus on exploitation of a vulnerable family, calls for legal accountability and transparency. That timing is not neutral. It places the harassment squarely inside the scope of the broader investigation. Why platforms matter less than people think. Some assume that because content was removed by a platform, the issue ends there. In reality, platform enforcement is only the starting point. When content is taken down for bullying or harassment, it creates a documented record. Timestamps, account identifiers, IP-related metadata, user associations. Platforms retain far more information than users realize, even after removal. When law enforcement requests that information, it is not a fishing expedition. It is a data-driven follow-up. That is why harassment tied to an active case is not dismissed as internet noise. It becomes traceable conduct. Why investigators ask the question they asked. When authorities reportedly asked whether Patrick Rourke might be behind the intimidation, directly or indirectly, they were not making an accusation. They were establishing scope. Investigators are trained to identify whether harassment is isolated or coordinated. It is organic or reactive. It is random or targeted. Asking that question signals that the conduct fits a known pattern. Intimidation following exposure. That pattern appears most often in cases involving financial exploitation, vulnerable victims, public fundraising, reputational stakes. All four elements exist here. The mistake people make when they escalate. Here is the paradox that repeats in case after case. People attempt intimidation to shut things down, but intimidation does the opposite. It expands scrutiny. Once harassment is documented, investigators do not just look at the harassment. They re-examine the underlying case with fresh urgency. They ask, why is pressure being applied now? What is at risk if scrutiny continues? Who feels threatened by continued attention? In that sense, intimidation acts like a flare. It draws attention to exactly what someone hopes will be ignored. Why silence is not the goal of the system. Another misunderstanding is believing that investigations aim to quiet discussion. They don't. Investigations aim to preserve integrity. What concerns authorities is not criticism itself, but interference, witness intimidation, chilling effects on reporting, manipulation of public perception during active cases. When critics are targeted instead of rebutted, it suggests that rebuttal may not be available. That implication alone is enough to justify escalation. The broader context that makes this more serious. This situation does not exist in isolation. It exists alongside alleged financial exploitation, disputed donation flows, a fractured vulnerable family, unanswered questions about consent and authority. When intimidation appears in that environment, it is interpreted as part of a larger pattern of control. Control over narrative, control over access, control over who speaks. Those patterns matter far more than individual insults or videos. Why this is not about taking sides. It is important to be precise here. Evaluating third-party intimidation is not about deciding who is right. It is about ensuring that no one interferes with the process of finding out what is right. People often confuse accountability with allegiance. They are not the same. Holding intimidation accountable does not mean declaring guilt in the underlying case. It means protecting the integrity of the process while that case unfolds. The consequence, most people don't anticipate. Many assume the worst consequence of harassment is reputational. In reality, the more serious consequence is procedural. If intimidation is substantiated, it can affect bond conditions, supervision terms, judicial perception of risk, credibility of future claims. It can also influence how aggressively related evidence is pursued. That is why legal advisors consistently warn clients and their associates to avoid any conduct that could be interpreted as pressure or retaliation. Where this leaves the narrative. At this stage, the question is no longer whether criticism should stop. The question is whether intimidation will continue, or whether accountability will replace it. Because once intimidation is documented, the story is no longer controlled by content creators, supporters, or detractors. It is controlled by records. And records do not respond to emotion. They respond to patterns. The focus will shift to how intimidation intersects with the original exploitation allegations, why vulnerable victim cases are especially sensitive to this behavior, and how attempts to control the narrative often reinforce the very concerns investigators are already examining. When harassment appears during an active case, do you see it as defense or as evidence of instability? To understand why allegations of intimidation around the Whittaker case are treated with heightened seriousness, you have to understand one foundational principle of modern investigations. Cases involving vulnerable victims are not evaluated the same way as ordinary disputes. They can't be. When a case involves people with limited capacity, social isolation, dependency, or impaired ability to advocate for themselves, the system assumes risk first and asks questions second. That's not bias. It's design. And it's exactly why intimidation, real or perceived, raises alarms immediately in this context. Why vulnerable victim cases operate under a different lens. The Whittaker case does not exist in a neutral category. It involves allegations tied to individuals who are widely recognized as cognitively impaired, socially isolated, and dependent on others for protection, access, and decision-making. That alone changes everything. In such cases, investigators are trained to look beyond individual acts and focus on power dynamics. They ask, who controls access to the victims? Who controls money generated in their name? Who controls the narrative the public sees? Who benefits from silence or confusion? When intimidation appears anywhere near that ecosystem, it is not treated as incidental. It is treated as a potential extension of control. Control is the through line investigators look for. One mistake people make is viewing intimidation as an isolated reaction. Someone got angry. Someone lashed out. Someone went too far. That's not how investigators see it. They see intimidation as part of a continuum. Control of access, control of resources, control of narrative, control of dissent. When those elements align, the question becomes whether intimidation is being used to preserve an existing power structure. In the Whittaker case, allegations already center on control. Control over donation channels. Control over content. Control over who spoke for the family. Control over who challenged that arrangement. So when critics report harassment, the system does not ask, was this rude? It asks, Does this fit the pattern? Why timing matters more than tone. Another critical factor is timing. The reported intimidation did not emerge during a quiet period. It surfaced after an arrest connected to alleged exploitation, renewed scrutiny of financial flows, public questioning of unpaid obligations, calls for legal accountability. That timing is not neutral. Investigators are trained to note when pressure appears after scrutiny intensifies. It suggests that something about the scrutiny is perceived as threatening. Threatening to whom is the next question. The chilling effect problem. One of the most serious concerns in vulnerable victim cases is the chilling effect. A chilling effect occurs when people who might otherwise speak up choose not to because they fear retaliation, exposure, or harassment. In cases like this, those people could include witnesses, donors with records, intermediaries, advocates, even family-connected individuals. If intimidation discourages them from coming forward, the victims lose protection. That is why intimidation is not treated as a side issue. It directly interferes with the system's ability to determine what happened. Why investigators don't need a perfect victim. Some supporters of those under scrutiny argue that critics are not neutral, that they have opinions, or that they are outspoken. That argument misunderstands the standard. Investigators do not require victims or reporters to be likable, calm, or perfectly neutral. They require credibility and documentation. When harassment is reported alongside screenshots, takedown notices, and identifiable affiliations, it becomes evidence regardless of personal tone. The law does not reward politeness. It rewards substantiation. How narrative control intersects with exploitation allegations. This is where intimidation becomes especially relevant to the underlying case. The original allegations involve exploitation tied to visibility, monetization, storytelling, audience engagement. In other words, narrative mattered from the beginning. So when intimidation is used to influence who tells the story now, investigators naturally ask whether the same impulse is at work, controlling perception to maintain benefit. This does not require proving malicious intent. It requires showing consistency of behavior. And consistency is exactly what pattern-based investigations are built on. Why? I didn't tell them to is not a shield. A recurring defense in third-party intimidation situations is distance. I didn't make the video. I didn't send the threats. I didn't tell anyone to do that. But distance does not eliminate responsibility under supervision standards. When a person is connected to individuals who act in their interest, and when those actions align with the person's legal or reputational needs, investigators look at foreseeability. Was it foreseeable that associates would attempt to silence critics? Was there any effort to discourage that behavior? Was there any public repudiation? Silence can be read as tolerance, and tolerance can be read as consent. Why the Whittaker family remains central. It's easy for this story to drift toward personalities, creators, and online factions. Investigators do not allow that drift. They continually bring the focus back to the victims. The Whittaker family remains separated, vulnerable, dependent on systems they do not control. Every action around this case is evaluated based on one question: does this protect them, or does it increase risk? Harassment and intimidation increase risk. Always. Why law enforcement treats this as additive, not separate. Another misconception is that intimidation is a separate issue, disconnected from the original case. In reality, it is additive. It can expand the scope of inquiry, justify additional conditions, influence charging decisions, affect credibility assessments. Investigators don't need intimidation to prove exploitation. They use it to assess behavior under pressure. How people behave when challenged tells the system how they may have behaved when unchecked. The strategic error that keeps repeating. From a purely strategic standpoint, intimidation is one of the worst responses available. It signals insecurity, loss of narrative control, inability to counter facts with facts. It also invites precisely the scrutiny people hope to avoid. In high-profile vulnerable victim cases, restraint is the safest path. Aggression is the loudest red flag. What this means going forward. At this stage, the situation has shifted. The case is no longer only about alleged past conduct. It is also about present behavior. Investigators now have reason to watch how criticism is handled, how supporters behave, how narratives are defended, how pressure is applied. Those observations do not fade. They accumulate. The focus will move to consequences, not predictions, not accusations, but the realistic procedural outcomes that often follow when intimidation becomes part of a vulnerable victim investigation. Because at that point, the system stops asking what happened and starts asking what is happening now. Do you think intimidation strengthens a defense or exposes deeper problems the system is already watching for? By the time intimidation becomes part of the record, the case has already changed shape, not emotionally, procedurally. This is the point where many people misunderstand what the system does next. They expect dramatic moves, immediate arrests, public statements, sweeping announcements. That almost never happens. What happens instead is quieter, slower, and far more consequential. The system tightens. Step 1. Intimidation gets logged, not argued. When allegations of harassment, doxing, or threats are reported in the context of an active investigation, authorities do not debate motives in real time. They document. Documentation includes dates and times, platform takedown reasons, account identifiers, known affiliations, proximity to key case events. This information is logged alongside the original investigation file. That matters because it creates continuity. From that point forward, intimidation is not new drama. It is additional conduct evaluated within the same ecosystem of risk. Step 2. Risk assessment is recalculated. Bond, probation, and pretrial supervision are built on one core concept: risk management. The system asks, is the individual likely to interfere with witnesses? Is there an attempt to shape testimony or silence critics? Has behavior changed since release or supervision began? When intimidation is reported, especially by people connected to a vulnerable victim case, risk assessments are revisited. This does not require proof beyond a reasonable doubt. It requires reasonable concern, and that is a much lower threshold. Step 3. Affiliated conduct is treated as a warning signal. This is where people make a critical mistake. They assume that unless a person directly sends a threat, nothing attaches to them. But in supervision contexts, responsibility is broader than that. Authorities look at whether associates are acting in alignment with the individual's interests, whether the conduct benefits the individual, whether the individual discouraged or condemned the behavior. Silence matters here. If harassment appears and there is no public effort to stop it, that absence becomes part of the evaluation, not as proof of guilt, but as evidence of tolerance. Tolerance increases perceived risk. Step 4. Narrative control becomes a red flag. In cases involving alleged exploitation through content and donations, narrative control is not incidental. It is central. Investigators are already asking, who controlled messaging? Who framed the story? Who decided what the public saw? So when intimidation appears aimed at critics or alternative narratives, it fits into an existing concern: control over perception. That alignment does not need to be proven malicious. It only needs to be consistent. And consistency is exactly what pattern analysis looks for. Step 5. Supervision conditions can change without public drama. One of the least understood aspects of this process is how quietly consequences can occur. If intimidation raises concern, authorities may increase monitoring, tighten communication restrictions, limit contact with certain individuals, issue warnings through counsel, revisit bond or supervision terms. None of that requires a press release. From the outside, it can look like nothing happened. Inside the system, the case posture has shifted. Why vulnerable victim cases trigger faster containment? In cases involving adults with limited capacity, the system is designed to err on the side of containment. That means limiting exposure, reducing chaos, minimizing interference. Intimidation threatens all three. It introduces fear. It discourages cooperation. It increases volatility. So even when intimidation does not lead to immediate charges, it often leads to increased caution. And increased caution narrows options. The compounding effect most people miss. Another misunderstanding is thinking intimidation is evaluated once and forgotten. It isn't. It compounds. Each incident becomes context for the next decision: charging, plea negotiations, credibility assessments, sentencing considerations if convictions occur. Even if intimidation never becomes a standalone charge, it can influence outcomes in indirect but meaningful ways. Judges notice patterns. Prosecutors remember conduct. Investigators connect timelines. Why this rarely helps the accused? From a purely strategic standpoint, intimidation almost never benefits the person it appears to protect. It expands scrutiny, undermines credibility, signals instability, suggests fear of continued inquiry. In vulnerable victim cases, it also reinforces the core concern: misuse of power. And misuse of power is exactly what the system is trying to prevent. The difference between defense and interference. It's important to draw a clean line here. Defense is presenting facts, challenging evidence, asserting rights, disputing allegations. Interference is silencing critics, intimidating observers, discouraging reporting, manipulating narrative through pressure. The former is protected, the latter is not. When defense turns into interference, the system reacts. Why silence from leadership figures matters. Another factor investigators consider is leadership response. When harassment occurs within a supporter circle, authorities watch to see whether prominent figures condemn it, distance themselves, call for restraint. Failure to do so is not illegal, but it is informative. It suggests either loss of control or unwillingness to control. Neither reassures the system. How this intersects with ongoing exploitation questions. Remember, the original allegations in this case involve exploitation tied to vulnerability, money, and visibility. Intimidation intersects with that because it shows how power is exercised when challenged. If power responds to scrutiny with pressure rather than transparency, investigators ask whether similar dynamics existed earlier, when oversight was weaker and victims were less protected. That question does not require an answer today, but it stays on the table. What the public often gets wrong at this stage. People often assume that if no immediate action is visible, nothing is happening. That assumption is wrong. At this stage, the system is observing, logging, narrowing tolerance, preparing contingencies. It is not reactive. It is methodical. Why this phase is about containment, not punishment. The goal here is not to punish speech. It is to prevent harm. Containment ensures witnesses feel safer. Reporting remains possible. The case proceeds without distortion. Intimidation threatens all of that. That is why it is treated as a serious development, even without headlines. Where this leaves the case now. At this point, the Whittaker case exists in two overlapping frames. The original allegations of exploitation and fraud. The emerging concerns about interference and intimidation. Neither replaces the other. They inform each other, and both are now part of how the system evaluates risk, credibility, and next steps. The focus will turn outward, away from procedure and toward impact. How intimidation affects witnesses, donors, advocates, and ultimately the vulnerable family at the center of this case. Because at the end of the process, the system is not judging popularity, it is protecting people. Do you think intimidation changes how authorities view a case, even if it never becomes a formal charge? By the time intimidation enters a case like this, the damage is rarely limited to the person being targeted. In vulnerable victim investigations, the real harm spreads outward, affecting people who were never part of the conflict, but who matter deeply to the outcome. That is why authorities treat intimidation as more than misconduct. They treat it as a threat to truth itself. The first group affected, potential witnesses. In cases involving alleged exploitation, investigators rely heavily on people who are not formal victims, but who hold pieces of the puzzle. These can include neighbors, intermediaries, donors, volunteers, or people who interacted with those managing access to the family. When those individuals see critics being harassed, doxxed, or threatened, a calculation happens quietly. They ask themselves, is it safe to talk? Will my name be dragged online? Will I become a target? Is staying silent easier? This is the chilling effect in action. And once that effect sets in, information dries up. Not because it doesn't exist, but because people decide the cost of speaking is too high. From an investigative standpoint, that is serious harm. The second group affected, donors with records. In this case, donors matter. Financial trails matter. Receipts, screenshots, transaction IDs, messages, and timelines matter. Authorities have already shown interest in donation flows tied to the Whittaker story. That means donors are not just supporters. They are potential fact holders. Intimidation discourages exactly the people investigators need most. A donor who might otherwise come forward with proof of where money was sent, instructions they were given, representations made to them, may decide to stay quiet if they believe speaking up will result in harassment. That silence does not protect the accused. It protects uncertainty, and uncertainty prolongs cases. The third group affected, advocates and helpers. Another often overlooked group is people who tried, quietly or publicly, to help the Whittaker family. These are individuals who attempted to coordinate legal help, sought reunification, looked for off-camera support, questioned the direction of events. When those people are attacked, a clear message is sent. Involvement comes with risk. That message discourages ethical intervention. It leaves space for only two roles: those in control, those watching silently. That is not a healthy ecosystem for vulnerable adults. The group most affected, the Whittaker family. All of this ultimately circles back to the people at the center of the case. The Whittaker family does not benefit from intimidation. They do not gain clarity from it. They do not gain safety from it. What intimidation does is increase isolation. It narrows the circle of people willing to engage. It reduces outside scrutiny. It discourages oversight. And in vulnerable victim cases, isolation is one of the primary risk factors the system tries to reduce. That is why intimidation is seen not just as hostile behavior, but as something that actively increases danger for the very people the case is meant to protect. Why authorities prioritize impact over intent. Supporters sometimes argue that intimidation was not intended to affect witnesses or donors. That argument misunderstands how impact is evaluated. The system does not require proof of malicious intent to act. It looks at foreseeable consequences. If intimidation reasonably discourages cooperation, that effect matters, regardless of what anyone claims they meant to do. This is especially true when the person who benefits from silence is already under scrutiny. How this reflects back on the accused. When intimidation appears around a case, authorities ask a simple but powerful question. Who benefits if fewer people speak? If the answer points toward someone already involved in the investigation, concern increases. That does not mean guilt is assumed. It means risk is reassessed. And risk reassessment affects how closely behavior is monitored, how much tolerance exists for future missteps, how credibility is weighed moving forward. None of that requires a new charge. It happens quietly, but it matters. The mistake of treating intimidation as loyalty. Another misconception is viewing intimidation as loyalty or defense. From a legal and investigative perspective, it is the opposite. Loyalty looks like restraint. Defense looks like evidence. Confidence looks like transparency. Intimidation looks like fear of exposure. That perception does not help anyone connected to the case. Why this phase is about protection, not punishment. It is important to be clear about one thing. At this stage, the system's primary concern is not punishment. It is protection. Protection of witnesses, donors, advocates, and most importantly, the vulnerable family. When intimidation appears, protective instincts activate. That is why the system tightens. That is why tolerance narrows. That is why conduct that might once have been ignored now carries weight. The question that now shapes everything. As this case moves forward, one question sits beneath all others. Will pressure continue, or will accountability replace it? Pressure increases scrutiny. Accountability stabilizes cases. One prolongs harm. The other creates resolution. Where this leaves the public. For observers, the responsibility is not to choose sides. It is to resist being used as instruments of pressure. That means questioning harassment, not amplifying it, valuing documentation over drama, understanding that silence achieved through fear is not truth. Cases like this are not solved by volume. They are solved by clarity. Final thought. Intimidation does not erase questions. It sharpens them. It does not protect reputations. It endangers them. And in vulnerable victim cases, it does the one thing the system will always react to. It increases risk to people who cannot protect themselves. That is why it matters. That is why it is documented. And that is why it will not be ignored. Do you think intimidation discourages truth, or does it ultimately make investigators dig deeper? Thank you for watching this video. Click here to watch another video that might interest you.